I'm Tom Zuber. I'm the managing partner of Zuber, Lawler, and Duca. We represent clients throughout the world, from offices in California, Illinois, and New York. I personally work on intellectual property litigation, deals, and global portfolio management. The other 40 attorneys at my firm also have experience with mergers and acquisitions and initial public offerings. Our attorneys work in languages covering 90% of the world's population. Today, I'll talk about federal trademark protection for cannabis brands. I am a lawyer, but I'm not rendering legal advice in this video, and I'm certainly not offering any advice as to the usage or sale of cannabis. I'm passionate about cannabis, and I'm passionate about intellectual property, and that makes the topic of federal trademark protection for cannabis brands a fun topic for me. Now, let's correct a common misconception. The misconception that it's not possible to obtain federal trademark protection for cannabis brands. It is. However, before we get to federal trademark protection for cannabis brands, I'd like to provide some context to establish why federal trademark protection is so important. There are three basic levels of trademark protection. The first level of trademark protection is common law trademark protection. Common law trademark protection refers to trademark case law that we inherited from England. Common law is based on cases, not statutes, and it exists whether you're trying to obtain it or not. You have common law trademark protection over your brand through mere usage of your brand in commerce within the relevant state. On the other hand, common law trademark protection is relatively weak. For example, if you sue a competitor based on common law trademark rights relating to your brand, you must prove that you actually own the mark. This is time-consuming and very expensive. The second level of trademark protection is state trademark registration. This is a bit better than common law trademark protection. There's a record that you've laid claim to ownership of your trademark in regard to that state's commerce. However, in a suit based on state trademark registration, the owner must still prove ownership of the mark. And again, that's time-consuming and very expensive. Furthermore, the registration applies only to the relevant state. So as an example, if a competitor begins using your brand in a second state in which you have not used or registered your mark, that competitor is building senior rights to that mark in that second state. To be clear, that competitor may sue you if you use your own brand in that second state in the future. Obviously not a good situation. The third level of trademark protection is federal trademark registration, and it's the most powerful level by far. As an example, a federal trademark registration gives you protection over your brand throughout the land, throughout the entire country and its territories. Furthermore, a federal trademark registration application can be based on intent to use. That's a big deal as well. You don't actually have to be using your mark in interstate commerce in order to apply for a federal trademark registration. And the date that you file your application still holds sway. This means that if somebody were to begin using a similar brand in association with similar products after the date that you filed your federal trademark application, should that application result in a registration, you could sue that competitor and win. This is true even if you started selling your products after your competitor did. Powerful stuff. As another example of the power of federal trademark registration as opposed to state registration, the owner of a federal trademark registration is presumed to own the trademark. That is a very big deal. That means that should you, as the owner of a federal trademark registration, sue a competitor in court over the use of your brand in relation to similar products, you don't have to prove that you own the mark. It's assumed. You don't have to gather the evidence to prove that you were using it first, which could be very costly. So when you send a cease and desist letter saying, I own a federal trademark registration for this brand, and you need to stop using it, the letter carries more weight because it's easier for you to execute on that threat. As another example of the power of federal trademark registration, a federal trademark registration allows you to obtain what's called statutory damages. This means that even if you aren't able to prove a penny of actual loss, the federal trademark statute will allow you to recover damages, and these damages can be significant. In the cannabis industry, federal trademark protection takes on a new, higher level of importance. This is a function of the fact that it's illegal to transport product across state lines. Currently, cannabis is a prohibited Schedule I substance, though various states have legalized cannabis at the medicinal and even at the recreational level. The federal government is not. So, it's not viable to transport product across state lines. This means that while you're building your brand in one state or two states or three states, a competitor could be building a competing brand that's confusingly similar to your brand in another state, precluding you from growing your trademark across the land. Now, let's fast forward to the day after prohibition ends, meaning the day after cannabis is declassified as a Schedule I substance. If that does happen, at that point, The value of cannabis companies is going to be a function of whether or not that cannabis company has secured trademark protection throughout the nation and throughout the world, as opposed to state-by-state protection for the relevant brand. So how do we do it? How do we obtain federal trademark protection for cannabis brands? Now, we're not talking about federal registration for hats and t-shirts and jeans, which in my view is pretty meaningless unless you're in the clothing business. We're talking about federal trademark protection for cannabis brands in relation to products that actually matter to cannabis businesses. First, we need to recognize that the federal trademark statute does not prohibit federal trademark registration for cannabis brands per se. Rather, the federal trademark statute prohibits federal trademark registration for cannabis brands in connection with cannabis products. What's the difference? Well, let's get specific. Let's say that you've obtained a federal trademark registration for brand X in relation to non-cannabis vape pens, and you've only ever done business in the state of California. This would require that, now or in the future, in addition to selling cannabis vape pens under brand X, you also sell some small but material amount of non-cannabis vape pens under brand X. Let's say also that a competitor is using brand X in relation to cannabis vape pens in the state of New Jersey. Well, you'd be hard-pressed to find a federal judge that would enforce a federal trademark registration to recover cannabis revenues before Prohibition ends. But the day after Prohibition ends, which is to say the day after cannabis is descheduled as a prohibited substance, you could show up in federal court and sue your competitor based on your federal trademark registration for brand X in relation to non-cannabis vape pens against your competitor's usage of brand X in relation to cannabis vape pens in the state of New Jersey. And if a jury finds that those cannabis vape pens are within what's called the zone of expansion of non-cannabis vape pens, that jury can fine for trademark infringement. All of this holds true even if your competitor used brand X in New Jersey before you did. Let me explain. Under the federal trademark statute, you can file a federal trademark application for brand X even before you begin using brand X in interstate commerce, based on an intent to use. And the date on which you file your federal application is the determinative date. So in sum, if you file a federal trademark application for brand X today, even before you've begun using the mark, and your competitor begins using brand X in New Jersey a year from now, and you begin selling products in California 2 years from now, if your trademark attorney has done everything correctly, when Prohibition ends, you could show up in federal court to sue your competitor. And other things being sufficient, you'd win. Now, filing this federal application is an involved process. For example, it's vital that your trademark attorney be completely upfront about the fact that you sell cannabis products in association with this brand or intend to. Otherwise, arguably, you've committed fraud on the Patent and Trademark Office, and another trademark attorney could submit to obtain a cancellation of your trademark registration should it ultimately issue. And what good is that? This means that it's important for your trademark attorney to surgically articulate the difference between the fact that you're requesting a federal trademark registration for non-cannabis products from the fact that your company also sells or intends to sell cannabis products in association with that same brand. Like other industries, the cannabis industry will be driven by brands, and cannabis brands can be protected at the federal level. That's all I have for today. I hope you found this video helpful. If you have any questions, please feel free to reach out. Thank you for your time.